So today I am planning to wrap up internet law, and then there would be two recordings of my previous lectures that I'll send you the link for. And that's going to cover anything that's remaining, which is not much, probably about 5%, including the ethics part. So let's get going with where we left. Now, I've got to look at um, some of the type of infringements on the IP side. Finish that up. Okay. 5 squatting, cyber squatting. Okay. So on this slide, we are going to discuss some internet related infringements, particularly to do with piracy, caching, page linking. So these are the three types of infringements. And here we are talking about copyrights, right? Piracy, you understand it is a direct infringement and it is like unauthorized copying or using somebody's work. Hey, Anthony, welcome. Uh, so we're talking about intellectual property hasn't finished on the copyrights, and I'm going to show you some of the infringements that are related to copyright. Number one is the piracy. Piracy, as I was explaining, is a direct infringement. Which I don't need to explain much. Piracy is unauthorized copying and use of somebody's work. Then we've got another thing which has to do with technology. It's called caching. Caching means that you are temporarily holding somebody's web page in your server or on your machine or somewhere where you can conveniently display that as if it is coming from a local server. So that is caching. Caching technically means temporary holding of somebody's work or any web page that you are keeping for reuse or for it to be made visible to you at the time when you call for it. So that is caching. Right now, there is a little bit of controversy on whether to consider caching as type of infringement or not. And the reason being that Google itself is actually doing extensive caching. Caching in the sense that as soon as it copies the web pages and stores it as in the indexing system, it is basically performing a caching or the act of keeping those pages for being called later by the users in its indexing system is caching. So technically, caching from the Google's perspective, the pages that are actually intentionally available or made available by the producer of those pages to be kept for someone to access them or to view them through the means of search engine or the search engine indexing, that is not considered to be the IP infringement. Okay. We don't want to get too much deeper into why not, because Google has settled this many years ago. And therefore, that type of caching is not an IP infringement. However, if there is a private caching, which is of pages that are captured and reused for private reasons, that is the type of caching the IP is calling as infringed caching. Number three, pages linking. Now, this type of IP infringement is very common, and at times people don't realize it. But explaining the type of page linking, you will understand what I'm talking about. So there is one that we call deep linking. Now, what is deep linking? Deep linking means that you have something on your website that is appearing as a link, which is leading you to the web pages of somebody else, or the domain that is called, which is linked to those pages, is called deep linking, which gives access to those pages through links embedded in that website. So when that website is doing deep linking, it is actually doing copyright infringement. I'll tell you one of the reasons for deep linking. Deep linking usually means that when a link is going to be calling or taking somebody to another person's domain, breaking out of the current domain that they're browsing or they are navigating, then what it is causing is for the user to go to that specific content page of that other website, which means it is actually bypassing the home page and the successive navigational hierarchy of how the pages needs to be searched if they were not deep linked, meaning that the home page where the domain has the ownership of its subsequent pages leading to the sub navigations, those are bypassed, as if the process itself is broken down when somebody else's is navigating to another site's particular web page or that content page. So that sort of is a technical issue which might give rise to a claim by those who own that website and web pages where this infringer is linking its pages to. Okay. So that is called deep linking right here. Okay. Then we've got something called inline linking. What inline linking means is that you're calling a design, a logo, or some sort of any kind of picture or even multimedia to be linked in such a way that it is actually going to bring that picture to appear in this infringer's website. And this type of linking is very common and very easy to do. For instance, remember how you put somebody's logos or somebody's picture on your site without changing or naming the picture, but rather just leaving a link behind it. So when you click on that picture, it actually breaks away from this domain and takes you to the actual origin or original page where that picture has rightly copyrighted and placed by the owner of that website. So you are only calling those pictures to be displayed on your website as if it is generated internally from that internal server, which is not a fact. And basically, it is really calling those pictures to be displayed or that multimedia to be run on that particular website. So that is called inline linking. Third is the framing. What framing entails is a technology which allows for somebody's content to be run and basically execute within a frame that is physically created inside of somebody's web page to display the content of somebody else. Even dynamic content can be called and displayed with that script which is copied and pasted within the frame. So anytime something changes on the other website where it is linked to, the frame would be displaying that file inside of that frame. Another characteristic of a frame is that it simulates as if that content is originally generated or is part of that web page only because the colors or the design or the area which is displayed. um, s- Frame, by the way, is like a box. Just think of it as a box that contains the script which is actually executing somewhere else, but it is being displayed on your page. So that frame that you create through hard coding is something which is basically an infringement of the copyrights of somebody else. Then, of course, linking to infringing work. Anything that is linking or has a link which is taking somebody to another site which already has the pirated content or already infringed work, that is what we mean when we say linking to infringing work. So page linking in the from the technical perspective is explained to you. And if you want to know a little bit more and learn something out of the book, which I will show you, there is a link that I discovered which explains it even better. So I'm going to copy and paste that link in the chat box. Perhaps you want to get a better review or a quick review using that. Is this the one? Yeah, this is the one. So let it just come up. I'm going to copy this and put it in your chat box. And this is for your information only, which means that it is something that would, if you didn't get the understanding, perhaps this read will make it more explainable. Now, next, the copyright licensing. So there are these licenses which are actually, I mean, you can Google it also just to see what is a fair use clause, what is GNU type of license, or GPL or GNU is the same thing. What is Creative Commons? So these are framework of legal bindings that are placed according to the organizations, which um, makes it more legit for anybody to apply those licenses in the internet world or in the virtual world for digitized files, fair use, GNU, and Creative Commons. Now, I have a slide which I guess I have shown before. For instance, if you type Creative Columns and look at the type of licenses that one can subscribe to, or basically, and this is free for anyone who wants to, let's say, safeguard their work under Commons, but within the license types inside of Commons. And this is one example. Then there are GPL or LGPL licenses as well. You can see that under the GPL licenses, which is a separate body apart from Creative Commons, there is GPL and LGPL are used for softwares, whereas Creative Commons is used a lot in case of written work or any content that is digitized, even including some of the books that are in public domain, including ebooks. But here, GPL and LGPL is identifying and basically more cordial to apply inside of or for any software code that you copy and use. You must have heard something um, like in the software side, they call it a public license, or sometimes they call it open source codes. They're all basically having some sort of framework of what type of clauses would regulate the use of it without compromising somebody's intellectual property. And this is governed by the GNU or GPL and LGPL public licenses. Okay. So that is one part that we can cover, we have covered. Now let's look at the trademark situation. Now, trademark has some, and I think I've explained it quite clearly what could be some of the ways in which trademarks are protected, or what could be the liabilities and obligations for both parties, being plaintiff and defendant. And if there is something infringed, then how do you contest the trademark rights. That we have done already. Okay, never mind, Majdi. Everything's getting recorded, so even if there's technical issue, you can count on something that you will get as recording. So don't worry about it. Um, Inside of the trademark infringement, there could be domain infringement, which means that people have a way of using the domain names or website links set in such a way that it creates a confusion. In other words, confusion for the benefits of someone who owns the domain name and someone who deliberately wants to sell the domain names by making it appear as if it is coming from the original vendor or a brand that is represented within the body of the domain name so that it simulates or looks as if it is coming from the original owner of that trademark. So, three things we will talk about. We'll talk about type squatting, cyber squatting, and page jacking. This I'm going to read from the book and I'm going to explain it in the simplest way by using these highlighted portions in the book. And here I'm looking at page 454. So, one of the ways people, anybody can buy a domain name. Nobody in from the registrar's office is going to verify unless it is educational institution or military or I guess these two are have got very stringent rules of obtaining the domain names. But other than that, for the commercial side with the businesses, you can get all sorts of domain names. uh, Given the flexibility and the availability of the naming of domain names that you can acquire and legitimately acquire, there are certain ways in which those domain names, even though allocated to you, but they can be contested or you can be held liable for trademark infringement. One of them is when, and here we are talking about type squatting. So if it is type squatting, what it means is when a person registers a domain name similar to a real domain name, but with a typo. So if somebody gets a domain name, for instance, PayPal, but with the Y, instead of Y, they just put PAIPAL, and it might be something that can be overlooked by anyone who is using that domain or looking for a page which simulates and looks similar to the original PayPal page. But if you look at carefully at the domain name, it would not be the same. Oh. Slight variations in the domain, that's type squatting. Then we've got something called cyber squatting. Cyber squatting that has a part of the domain name that makes it look or appear as if it is coming from the original subdomain, if not the actual domain, but it might be a subdomain or it makes you think as if it's a subdomain of the original vendor. For example, there used to be, and I remember from the practicality of when we got into trouble, there was a business I was a partner in, and it was called Memory for Less. Memory for no, I'm sorry. There was yeah, Memory for Less was one, but the other one was Cisco for Less. CISCO number four and less LESS.com. So what happened is that Cisco Systems, the company that manufactures the equipment for the networking, like routers, switches, and the like, that company actually came back and told us that we can no longer use this because the word Cisco, which does not make it a complete domain name, the true domain name for Cisco is ciscosystems.com. Therefore, it was not something that could have been a threat to us. Second thing is we were using Cisco to sell something which is actually coming from some memory parts for the Cisco equipment. And therefore, it was considered harmless. But, at that time, and I'm talking about 12, 15 years ago, at that time, the laws were evolving and things were getting straightened out with these kind of situations to clear up the legalities of the ownership of IPs. So we had to eventually give it up because part of it was Cisco, and the other part, which was for less, was an extension of the domain, or you could say that it was part of the domain name, but it was not completely giving the notion that it is coming from Cisco systems themselves. However, that was cyber squatting, and so we had to give up that domain name. So you understand the difference between type O squatting versus cyber squatting. Cyber squatting is not as deliberate, but typo squatting is through a scheme or through a well thought of plan to buy certain domains which would cause confusion in the eyes of consumers. So that was type squatting. Now, page jacking is an outright fraudulent thing, which means that again, I'm going to take this example of PayPal because that is pretty much standard for the those who are trying to gather or get your information, including password or access to your actual PayPal account. So the page itself that you are going to look at is will appear as if it is the original page coming from the owner of that brand name. And the only way you can figure it out is if you carefully look at the domain and see, because you see what the confusion a lot of times happen because you're accustomed to looking at subdomain names, which include the actual owner's name as part of it. For instance, when we did the example using mail.yahoo.com, it was a subdomain of Yahoo and it was originally the ownership of yahoo.com, and there was another domain like news.yahoo.com and so on. But the construction of the domain where the subdomain is broken up with the first name giving the indication that it is a subdomain followed by the actual owner's original domain name would have been the correct way of writing it. But when you see the word mail, for instance, followed after yahoo.com, that is not conventional and it could not be the actual domain. So when there is a situation with the page jacking, you can figure it out by looking at the address bar and seeing how the domain name is constructed. Second thing is that in page jacking, a lot of times you are running from one page to another, and whereas one page would make you think from the type squatting scheme that it is coming from the original, and you may have missed out the spelling, and then when you sub navigate to further pages, you will see that the total domain name starts to change. And visibly, you can see that even though the page is looking the same, but the link itself is not legitimate. Okay, then we are talking about linking and framing. Linking and framing within the domain name has the same meaning as it has in the previously explained IP deep linking and inline linking. So instead of repeating it, think of it as now being applied in terms of the domain. So linking to another domain, framing, which means that when the frame is played, you can see that the address bar would start to change. Okay. And you would see that in the extension of the domain on the top, where the original domain is shown for that particular page that you are in, that has the frame box in it. Yet, when you look at the extended form of the domain, you will see um, another um, website's domain also displayed as an extension as one of the folders, or it will be in the stem of another domain name would show up in the stem of that link. So you can tell if the framing is in play or not. So understanding the links and reading them every single time, especially if you are getting on some websites through links, it might be a good practice to actually observe what the address bar displays. Then, as far as trademark is concerned, the owner of the trademark or those who are suing someone for their trademark infringement will can sue you for two reasons, or they can create punitive damages as well as actual damages based on dilution of the goodwill. So, to quantify the damage, they need to figure out what could be the value of diminishing goodwill on account of somebody's tarnishing it or somebody's blurring their trademark. For example, the difference between blurring and tarnishing can be explained like this. Blurring happens when the okay, what causes blurring means that um, it is similar products, or it has the branding logo on it, okay, but it is got some differentiation in how the logo is put together, or how the marking, or if it is a design mark, how the design mark is slightly changed, or there is a variation to it. That is a blurring, which means visually it looks the same but it is not. So a Nike shoe would appear to be the same, but when you look at the spelling, it would say Nika or something different, slightly different, that a common consumer may not just be able to tell when they are not paying attention. So that would be a blurring of the goodwill or the blurring of the trademark. Tarnishing means outright copying something which is of inferior quality, where the logo and the branding is put in exactly the same, but the product itself is not coming from the original vendor. So, tarnishing of goodwill will have a higher cause or a higher value for claiming damages versus blurring. But both of these would cause the dilution. Dilution means somehow spoiling the goodwill of that brand by selling inferior or low quality products under their name, either by blurring it or by tarnishing it. So I hope this is clear. Now let's look at the patents. I told you on the page that I'm referring to now, 456. I told you that this chart is quite substantial for you to understand what the patent entails and what could be patentable and what is not patentable. So just by looking at those two columns, which says patentable or not patentable, you can pretty much understand the difference between patents, trademarks, and copyrights. Whereas generally trademark and copyrights are pretty much the typical way of how you would describe IP infringement, but patent requires a lot more of, I guess you could say, there is a onus of proof or a burden of proof or a higher level of burden of proof that you have to present in order for you to get out of the patent infringement situations. So, um, um, you want me to go through this, or you can read it and you can tell, ask me if there is anything that I can explain or anything I can better explain from this chart. Let me just bring it as a single page first.
Yeah, it's clear.
Um, The artistic work, artistic creations is what? Copyrights, mathematical algorithms or models. There is a lot of technicality involved here. Some mathematical algorithms are patentable, some are not. If something that is not innovative or is solving a problem through a methodology that gives rise to brand new algorithms, then you are basically solving a problem which has not been solved before by conventional algorithms or what was presented and what was run, talking from the scientific perspective, that did not provide the solution. So, if in case there is innovation in algorithms solving some issue, then of course it becomes patentable. But what is described in this column is a generality and not a specification of what is considered. Now, software generally is abstract, intellectual, or mental concepts or process. Remember, you were asking, or Mejdi was asking about the process. So, in the software development, if it is a process of a software, for instance, if it is an innovative process, which is a new process, but it is applying something which pretty much is standard coding or a coding which is using, let's say, Java. Java does not have an ownership because it is open source, but certain coding may have the ownership, means that you have to be working inside of a certain kind of environment to make that code work. That makes it copyrightable. But if it is an open domain, a lot of softwares, including the, what was it, Linux, there are certain Linux flavors that, like SUSE, Linux SUSE, I remember, and it's a long time ago, I'm not up to date, was more on the patent side. Whereas the Linux as an open source server was, in the public domain. So that was actually held within the GPL or LGPL licensing. So there is these things, but paying attention to what is written in the first column, this one right here, that there has to be innovation, it has to be novelty, means that it has to be new, it has to be inventive. So in legal systems, inventive is defined, novelty is defined, and things like use utility of it is defined. What does it mean by utility? Utility means, is it going to benefit public in general, or it would have a value that can be put in terms of commercial license, or it has a value which is sellable. So all those will be defined in greater detail if you are to read the patent law, which is not where we are heading right now. The reason why we've included patent as an intellectual property, to understand a little bit about it, is only to distinguish trademark and copyrights from patents. More you will be dealing with patents, with copyrights and the especially copyrights, and little bit on the trademark situations when you're doing research and you're reproducing or using somebody's work. Okay. Now, I want you to also understand that while we are learning about what is important, there would be certain type of information in the book that I would say that you can safely leave out. Or it could be something which is more on the excessive side, or an additional information which may not be as important, because I am looking at things from the perspective of the examiner, to see what the examiner objectives are to test you uh, inside of those chapters, which are very specifically um, 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 dealt with from the point of view of learning certain concepts, from the eyes of the examiner only, not from the eyes of someone who has written the book. Okay. So, one of the things that I would say that you don't have to worry about is things like encryption technology, anonymous servers, use of software, what are the different online privacy protection legislation. These are for references. And what is given to you here in a link is for you in case you want to use this book as a reference for situations which may be very peculiar or very specific that that would require for you to go and find out more through these different legislations, or whatever is named here are just an expression of where you can actually go and find more information on privacy issues. Federal statutes, don't have to worry about it. Electronic Communication Privacy Act of 1986. So it has got something to do with, say, USA Patriot Act, Homeland Security Act. You don't have to remember any of this because it is not the objective of the chapter that we are reading. Okay. So I'm going to talk a little bit about privacy after we take a break. Privacy is an important part, and you will see the um, you will see that there would be some aspects of privacy which directly or indirectly would link to your collection of information or methods of collection, as well as the subject from which you are collecting the information, human or non-human, if it is an entity, business versus individuals, and so on. So from that point of view, privacy part may be important, but we look generally what are the different types of privacies. And then I will talk about the defamation, which is going to only refer to two types of defamations. There's libel and there's slander. Okay. And there are certain type of contracts that I'd want to discuss. Cybercrime, generally, it is a common information, and all of us have a better understanding of things like hacking, cyber terrorism, internet identity theft. We all know we've dealt with it in our practical lives. We hear about it and we also have a general understanding. Terminologies: B2B is business to business, B2C is business to consumers. I'm just going through it a little bit faster than usual, but I will pause and I will explain more on things which require explanation or deeper learning. Okay, and then we will do the electronic contracts. So let's take a 10 minutes here, and I'll continue with the privacy part. Okay, then we'll do defamation. Here, leave this open, and I'll see you in about 10 minutes. Okay, I'm back. So let's get started. We have a lot to cover. Let's talk about private information types. Generally, the privacy depends on what the law provides for the common consumers to protect their personal information and the type of data which is considered private, um, based on, I guess you can say that, based on the regional value given to the level of privacy that the society thinks that people are entitled to. So, entitlement of privacy varies. For instance, in Saudi Arabia versus Russia or Eastern Europe versus North America, so the level or threshold of what is considered private varies, and this is governed by the law, which in turn is dictated by the constitutions generally under the federal legislations, and specifically um, within the norms of what the society considers private. Okay. So in North America, the threshold or level of privacy is higher than anywhere else, at least from my personal experience. But when we talk about the browsers or the type of information that is collected while you're using the websites, including social media, um, now those kind of sites have what we call there is two type of agreements that are actually there in a subtle way that is described, or it is available in small prints, or where the agreement of using those sites includes the privacy statements. So to say what type of privacy, generally there are two type of agreements um, on the websites. And I'm going a little bit ahead of what I'm discussing right now when I'm talking about privacies for the browser um, and the websites that you use. So there are two type of agreements. One is called click wrap agreement, and the other one is called the browse through agreement. It is defined somewhere here. I'll give you the page numbers. Here it is. There is click wrap agreement and browse wrap agreement. So two type of agreements by default are always there, which means that these are the only legal statements that you will encounter, other than the privileges that you get to keep certain type of information private and give away the other information just as a cost of you using those websites. Um, might as well just talk about click wrap while we are at it, and browse wrap. Now, click wrap agreements are the ones that you have to actually check. There is a checkbox, and you have to okay that, or somehow you are forced to check that box in order for you to proceed to the next level or the next page or the next step that you take, including when you're doing payments, buying something, or even when there is a contractual obligation which must be fulfilled before you can go to the next page, including databases that you have access to and so on. Those are called click rep agreements. And normally rep agreements are very detailed and are also sometimes called fine prints, where you not being as savvy in interpreting the legal language, but still, you are forced to check that box to say that you agree to it, and you can go to the next page. Whereas the browse rep agreement means that as soon as you land on those websites or web pages that belong to a certain domain, the use of it or just browsing through it would mean that you have assumed to agree, or there is an agreement by default for anyone to even look at those pages. And these type of legal terms are described as terms and conditions, policies, and all that you get to see in the footer portion of web pages. So that we call browse rep agreements. So when there comes a question of privacy, there is obviously these agreements that protect, perhaps you can call them a disclaimer, or you can call them something that allows for that website to collect certain type of information from you, would be legitimate, and would by law gives away a certain privacy rights, and it is actually voluntarily given. Now, three type of private information are described here. One, personal information available in online databases that you can access. Remember, certain information like people's telephone numbers or white pages. White pages is, I guess, you don't have to subscribe to it. So that's common information. As long as your phone number is registered somewhere, your name and your telephone number would just pop up. Other type of specialized websites that have a collection of someone's individual personal details, including websites, connection, including some other information like your residential addresses, for instance. All this is available as a publicly available data, but not a public data unless you pay for it and agree to certain terms and conditions of use of that information. So that is available through private information available in online databases. Okay. And by the way, in all circumstances, where you have agreed to giving away information, or have agreed to the use of that information, you also or those that you are collecting the information for or from, they may have always have the right to um, block that information from becoming sellable or being available through these channels, which are specialized in giving more details about someone who is who is using the online facilities, in whatever way they're doing it. Even the email data is collected, so that even if it is a personal information, it is still available. Then you've got data collected, but in all three cases that I'm discussing, please read the use of data, in what circumstances and in what situations, or for what reasons you can use it. So that is a restriction that will always be there. And think of it as a disclaimer of the liability that otherwise those who are providing that information might be held responsible for. Then you've got data collected during individual participation in online activities, including social media. However, there is one aspect of the information that is voluntarily considered as being um, given out just because you have agreed to what we call cookies. Cookies are small softwares that you can download, or it becomes downloadable, or sometimes it becomes, it gives you a choice of what level of cookies you would allow for it to sit on your machines. Now, what cookies do is that they collect a certain type of information um, under the guise of marketing reasons, or it could be something which would make user experience better for those websites to display some additional content, and so on and so forth. But what cookies are responsible for basically is collecting information based on your activity in that browser, away from the type of information that is collected by the browser itself. So this is an edit utility which sits on your computer, which has nothing to do with the browser itself. And when I say browser, I'm talking about Chrome, talking about Bing, whatever browser you're using, that has a separate infrastructure and a separate software, which is, kind of also doing a similar thing, but it is doing it in a different way. Whereas cookies would give away another type of information that connects and works for or with the websites that you have accessed and for which you have given permission for the cookies to get downloaded. Then we've got data collected and maintained by government institutions. Certain informations are made public for the general well-being or the welfare or the awareness of people to have uh, a certain level of information or certain type of information. For instance, a pedophile's information is obviously is collected from the side of the, somebody who wants to do a background check. Certain information is restricted but still available based on the use of it, or where the legal system would, under a subpoena, would subscribe to it, or would give rise to special licensing of accessing that information. As an insurer, your insurance companies, for example, would require medical record that otherwise is not available to a common user. Um, Certain records like birth and death certificates can be collected if you want to do that online. Of course, there would be a bit of information that would require for the website to authenticate you as having the rightful access to it or not, and so on. So these type of information are kept in the government institutions, and government only gives away certain information for the public interest in general, some information for having the right or under some legal framework. Certain institutions are able to obtain that for a specific reason. In most part, the just the part where you have the insurance company, for example, accessing your medical records for health reasons, for life insurance, as an example, they would have the right. But at the same time, when you are signing the contract with the insurance company, you are also given a form that allows for it to do certain background checks, including access to your medical record. So there is a voluntary form that is part of it as another layer of private information to be protected, and for which you are asked to give a blanket permission to get an access on your behalf. Even records like bankruptcy or your credit checks, that also requires a form to be filled and to be signed by whoever's information needs to be accessed. So there are these three that we are going to talk about right now. You looked at online databases, um, cookies, which are automated process, and data maintained by government institutions. And then when we talk about the privacies in detail, we will have to look into the laws which protect consumers. As an example, with the consumer protection law, there would be others that are listed here. For instance, um, Computer Fraud and Abuse Act. If there is something that is actually part of a criminal prosecution, and it needs to be identified for a certain type of fraud, you will have to subscribe to the Computer Fraud and Abuse Act. And so it continues. But like I said, this is not going to be part of the exam. Privacy in general, I told you these are three elements. As far as online privacy protection tools, there is encryption technology, which means if it is confidential document and something for which you need an exchange to be guaranteed as having no no options open, or where the special type of Encryption means that the document's name is not part of the link. It needs to be, and when the document is being exchanged, the whole connectivity of it from one end to another, like in branches and head offices, for example, is encrypted. Mostly encryption is done with VPNs or point to point, to make sure that it is something that cannot be hacked into, and even if it's hacked, it needs to be decoded for it to reveal the placement of that document. So the encryption technology works at different levels. At the network level, it works at the database levels, it works at the operating system, and so on. So encryption is the basic technology which hides the actual characteristics or actual identification of that document. Anonymous server is another one, which means that the server, which generally has an IP address to be recognized and to be acknowledged in the network, would actually not contain a public IP, but it would have an IP which is dynamically generated every single time someone accesses information through that server, and therefore it is called anonymous server. That means the placement of that server, the physical location of it, can never be revealed, or even the IP addresses cannot be identified exactly to that server. Okay. Use of software. So this is software protection, where you actually install a kind of software which filters something like Norton or something like McAfee, and all those softwares, they do have this option. So that's, some of the ways in which the protection is there. And that's about it on that topic of privacy. Now let's look at defamation. Defamation is important to understand because there could be question in the exam, and we will run through some of the examples similar to what we did with the intellectual property, where you are going to look at the case and read through the para and then answer the questions. So there is one on defamation. So what is defamation? Defamation means the act of harming the reputation of another. Now, harming the reputation would mean that you are not substantiating the level of harms by translating it into a monetary value. So even if it is a reputation related, which cannot be quantified, it still is a defamation, and one can be sued for it. And how the reputation can be harmed by making a false statement to another person. The act of defamation may be a false written or oral statement. So let's suppose we are talking about defamation. One aspect of defamation is actually mentioned here, which means the the information is real, it is not false, yet it can cause a harm to the reputation of somebody. So this can be contested, or this can be a question. So what if it is a true statement, okay, and not a false statement, but it is harmful to the reputation of someone? Yes, even uh, um, that can be prosecuted, and that can be something for which a plaintiff can file. And when we say a true statement which is harming the reputation, then comes the act or privacy act into play, because privacy act and defamation might be touching each other, or they could be at the crossroads, or they can back each other up. So privacy, certain type of acts are considered private, or it is the kind of information which may be obtained in spaces which are considered private spaces. Okay, so that could be, your private privacy that is captured, and that is put to harm, put to distorting or creating disreputation for you. So just keep that in mind. I thought I can just add this for you, even though the definition is right there. But this exception I'm bringing to your attention. The act of defamation can be a false statement, can be a false written or oral statement. So even if you are talking something about someone without putting it in writing or making it available in writing, it will still create a harm for anybody's reputation just by spreading the word or tweeting something that is not true. So when it is something that is oral statement or if it is written statement, in both conditions, it will cause the harm. And to distinguish what is the type of harms for the defamation with written and oral, you can look at libel. Libel has got other stricter and more well-defined elements that has to be part of any lawsuit that is caused through libel. Libel um, is a written statement, written anything that you wrote and you made it public. If there is something that you wrote and it has not become public or it has not spread to more than one person out of your own self, then it is not considered libel. So for it to be a libel case, it has to have, let's look at the ways in which you can uh, think of filing case for libel. The defendant published a defamatory statement about the plaintiff in written or another form, okay, and other people were exposed to that statement. So exposure is important. Harm is important. Publishing it is important. Okay. And it could be a true statement or it could be a false statement. But if it is a true statement, the Privacy Act would come into play, whether that information is considered private. In North America, like I said, the standard of privacy is different and would also include something that you are doing wiretapping for. So that could be an obtained information which may not be legitimately obtained and therefore cannot be played in the court of law because it is illegal act to do wiretapping. So even if it is a true statement, but it was wiretapped, the way in which you have obtained it is of consequence for it to be um, contested or it to be become part of the evidence in the court of law. Second is the slander. Slander is referred to as spoken or oral defamatory statement. There are two types of slander, it is saying. Okay. Then the first type, the plaintiff must prove the defendant made a defamatory statement to at least one other person, which again, like I said, it cannot be private. It must have spread, or more than one person has the knowledge of it, or you have actually said something about someone to another person. And the second is that it has suffered what is referred to as special damages. Now, slander special damages is the term used because these special damages have to be calculated, and it is not an easy task to do that. It just depends on the reputation of an individual who you have slandered. If someone is a public figure or is a famous personality or is actually a personality that has a contractual relationship with a third party that can be affected on account of slander, then the level of special damages would be higher. Okay. So these are the two things. Cyber defamation can happen on the websites, blogs, emails, mailing lists, social networks, internets, you name it. Okay. It can even be just you know just between common friends. So there could be so many ways in which slander can happen, and so these are just some of the examples. So just to recap, in establishing a case of defamation, three elements are required. This part is important, I would think, because I have seen questions in the exam that is pointing to defamation, one of which, out of these three, one of which can be, a misleading information. So you have to be careful, first of all, to understand that these three are the important parts. Nothing else that you can fit into the three different ways in which the case of defamation can uh, can be put in the court of law. So the publication to one other than the person of defame, so more than one person. False statement of facts is the second, that is understood as being of and concerning the plaintiff, tending to harm the reputation of the plaintiff. If the plaintiff is a public figure, he or she must also prove actual malice. Now, the word malice means intent. Sometimes you can, cause, um, you know, you can cause harm, may it be libel or slander, either way, without intention. Or it could be something which may be private or might be something dear enough for an individual who thinks of it to be private enough that it would impact somebody's marriage, somebody's relationship, somebody's contracts and obligations. But you were naive and you did not know about it. So the intent has to be proven in most of the cases when it comes to leniency or for the judge to act favorably for the defendant, the plaintiff, unless the plaintiff proves a malice or intent or a malicious intent behind it, it might not be as effective to prosecute someone. So a malice has to be there, means intentionally causing harm by planning something or for which somebody would have an ultimate benefit out of. So that would be a cause of malice, and malice has to be proven in the court as well. Electronic spams. So phishing, spams, advance bank payment, all of these are there. But when we say spams, it means the type of information or the type of advert. It could be anything that comes to the knowledge of commoner users who are not savvy enough or who are the type of people that may not understand and may not be able to make the difference between what is true and false, or what is given to them as a true statement um, uh, mistaken as true statement, but in fact it is false. So that is spamming. Spamming can come in different forms. Phishing scams, these are fake emails. Advance payments, pyramid schemes, get rich quick, and all of these. We have all come across it. A lot of our trash or the spam boxes contain all of these offerings, and we can identify it. So those are spamming. Then cyber crimes, there are two types of cyber crimes. Generally speaking, there is active and there is passive. Active crimes are basically when somebody directly hacks into someone's computer or actively pursuing someone to sign something or misleading someone by just simulating pages which appears to be true but they are not. Identity thefts and anything that is proactively or through scheme or well planned ways of getting to an information of someone is considered active type. Whereas the passive type is when somebody's servers are used, and therefore, it is not exactly directly attributed to the owner of that server or that software or whoever is on the other end that is giving access to their website. But knowing that or not knowing if someone is using their servers for illegal acts like kidnapping, you know, uh, leading somebody to go on someone's website or misleading someone by misinformation, anything that you can visualize that sometimes the social media account gives that opening for anyone to set up their goods and services, or business accounts may also be part of the passive type of crimes that can be easily can be done on the social media sites. Nature of the crimes. hacking, internet piracy, cyber terrorism, identity theft, online stalking, bullying, and sex crime. So these are just identifying some of the other types of cyber crimes, whereas the ways in which cyber crimes can be broadly differentiated in the court can be called either active or passive. So this is where we are going to conclude the cyber crimes. Not that we are specialists in cyber crimes. We are just identifying and calling and understanding what could be the criteria of distinguishing certain type of cyber crimes, and broadly what how the court looks at it from two ways in which active and passive can have different onuses, obligations, as well as a proof of harm. So those are the defamations. Now, contracts. In a contract, understand that a contract act, which is one of the oldest acts in law, contract means that it is an agreement of sort that creates obligations as well as create responsibilities for parties that are agreeing to something that they need to do together, and for an agreement to take place in a virtual world, you have to meet all the elements of a standard contract if it was in a print format. So, if print format contract, even if it is virtually placed somewhere and it is assumed to be either a click wrap or a browse wrap, whatever the nature of it might be, the contract is got to meet certain criteria for it to be become legal. What are those three elements or the three criterias? One is the offer. There has to be a clear offer that look, we you are using this you know this site, and we have all these things collected through a lot of effort. These are personal properties or intellectual properties, but for you to use it, you have to subscribe or whatever the condition is. That is considered offer. Acceptance is when you actually start to browse or you click on something. So that is acceptance of offer. And there should be a consideration, meaning that it should have some meaning for both parties. Like both parties should benefit in some way. Either it could be an exchange of money or just a subscription information, or the collection of something on the virtual platform that benefits both parties, both as users and the vendor of it. So that is called consideration. In real world, generally, you put it in writing and you actually itemize what is what is to become a consideration. Either it is the value in terms of dollars, or it is a barter or some benefit that both the parties would be agreeing to get or give through consideration. In e-commerce world, especially, there is two type of agreements. These virtual agreements are click wrap agreements and browse wrap agreements. Okay, and I've explained to you what is browse wrap and what is click wrap. Email is not considered an agreement, but it is used in the court of law as exchange of understanding or exchange of consideration of offers between parties. By the way, email itself, in the legal way in which it is dealt in US and Canada, may be slightly different. Like in Canada, email contracts have no value, or it may be considered as a MOU or something that identifies with the intent between parties, or consideration in terms of what is agreed as MOU, which is Memorandum of Understanding. But it is not a contractual obligation. It can also be used as an evidence in certain situations, being emails exchange, but it is still not a true agreement. So think of it as something that in US, I don't know, but there are certain communication laws which give rise to statement that can be placed as part of your emailing, and that statement might have will have a value in USA, but in Canada, those statements or disclaimers generally are not entertained or not considered as legally binding. Electronic signatures, there are different ways in one can actually get contracts signed through digital means. Like take an example of Adobe software. Adobe allows you to have a facility which would make a document more um, more like an obligation or a contractual obligation when the parties uh, sign it, whereas that signature is actually identified in two ways. One is that it can be a signature which can be copied and pasted as a graphic or as a file or as something that you have a pad for and you can sign it, and that signature is actually placed on that document to have a kind of a blueprint of what is acceptable or what is recorded in a third party server of Adobe PDF. Then there could be another option where an encrypted or a unique combination of alphanumeric characters is allocated to you or given to you with a numbering or with a reference that would make it unique and only identified for that period and for that individual who is using that encrypted alphanumeric characters to be placed in that document. um, the reason why these type of signatures or why encrypted signatures have a significance is because the third party is managing it and it is not the and the second thing is that those are automatically generated and kept as a record or as an evidence on a third party server for that allocated encrypted alphanumeric characters. They could be 12 in length or they could be 8 in length. It just depends. You have a choice in doing that with Adobe Documents. However, those digital signatures may not work in certain type of digital contracts. For instance, there is a big list of it, and this is part of the um, you can say rules in the legal system. Um, um, like, for example, if it is a land acquisition or a real estate contract, um, if it is a leasing contract, it has to be signed physically, it has to be signed in the presence of other witnesses, and therefore it may not be effective if this type of agreement is done on the computer or virtually somewhere. Even with the digital signatures, it is not considered as obligatory or binding in the court of law. So keep that in mind. Now, for the ethics part, I'm going to give you a recording. It's just going to be 20 minutes. We would be leaving out the chapter 39 because I'm going to now talk about some of the examples or the ones that I would think in the exam you will only get one question on the ethics or what the ethics is about. Maybe if I get a little bit extra time, I'll introduce you to what ethics means. But let's look at some of the examples that we would continue to do where we did our copyright example yesterday or a day before on previous class. Now I'm going to talk about link copying, then piracy, then plagiarism, then defamation, and e-commerce is the last one. So let's look at the case study number 2. I'm going to let you read this. For everybody, please see if you can read this clearly. These are the three paras. Try to understand and note down what it's talking about, and then we will we will discuss these questions. should be an easy one. You know what linking means? Linking is, when there is a picture, photograph of something which is actually published somewhere else, and you are copying and putting that on your own website with the link intact, even if that link is clickable and it leads you to another website which actually originally has published it, that is the format of linking. So if it is a linking where Larry, even though he is a photographer, even though it's his own actual work, but under a contract with the Natural Heritage magazine, he has given away that intellectual property to Natural Heritage. Yet, Larry feels entitled to have those pictures mentioned. Maybe he's just mentioning it as his work or as is part of the portfolio that he is presenting um, on his own website. Still, there is a question whether it is a linking or no, or if the Natural Heritage can sue Larry or not. Hmm. So, what is the copyright infringement case in this situation? The answer is obvious. The topic is linking. It is not piracy. He is not outright copying it and presenting it. He is actually using it to link the picture, which has clickable links, but it is placed simultaneously by the Heritage magazine and is placed by Larry as well. So that is linking. So what is the copyright infringement case in this situation is linking. It is spelled actually, it is linking. So you have to read it carefully. You could see that he has done linking. In the second one, Larry is responsible for direct copyright infringement, contributory copyright infringement, vicarious, none of the above. This is more important. So how would you think that the type of linking that Larry has done has anything to do with direct, contributory, or vicarious liability? Any of the three or none of the above?
Contributory.
Hmm? Sorry.
So my understanding is he actually took these pictures himself for natural heritage. That's why he feels like it's okay for him to share these pictures with other people because he took them for the magazine, but the magazine owns them now. And he's still trying to use the pictures as his own. That's correct. Is that correct?
Correct. The
Okay,
only thing.
so
Mhm. Yeah, the only thing is that here, read this. He sees the links that Larry had provided on his website linking to. Read this part.
yeah,
So if you read this part, you would know first of all it is linking. That means he's used the original link, which is actually the picture is there. But when you see pictures can be clickable or where it is identified with the heading or a caption what the picture is about. It could be an anchor link. Anchor link means that these are worded
right,
as text, but it is clickable. So
right,
it sort of, how you bring the browser, bring the cursor on top of that writing, you would see that it flashes, or
right,
you could tell that it is actually clickable.
right,
Uh, so when it is clickable, it is linking.
right,
So here it is a linking situation. Now, when he's doing linking, what he's party to is not direct copyright infringement. It would have been direct copyright, as you said, when he copied the image and just placed it on his website. That would have been copying, meaning that it is no longer clickable. It is just the same picture copied and pasted on Larry's website.
right,
That would have been a direct copyright infringement. But
right,
here, when it is a linking situation, you're dealing with a contributory copyright infringement.
Right.
So that's where I'm going to select contributory infringement.
Yeah.
And the third one says, what is the linking related to copyright infringement in this situation? What is the linking related to copyright infringement? I don't know how they word the question sometimes. I think either my English is incorrect or they have intentionally written it for confusing students. But anyway, I mean, this is as is. So it is coming from the examiner side. So I don't want to debate on this. I just want to get a better understanding of what the examiner is asking, saying what is the linking related to. So let's read the answers. Larry provides links on his website to copyright protected images. Larry refusing to remove links from his website. Larry argues that copyrighted images belong. I think what if he is refusing or if he is arguing, that is not the actual context in which the question is asking you to relate to the answers. What it's saying is that by using the word, what is the linking related to copyright infringement? What linking? Larry provides link on his website to copyright protected images, period. Anything else is not the cause for it to be called the IP infringement based on linking related issue. So to keep focus on linking related, I would prefer to use one as an answer because it's talking about links on his website to copyrighted protected images. Anyway, I wished we had time to debate these things, but like I said, I'm just, we can just use our common sense and the best that we can think of based on the what we read. What can Larry do to seek permission from the publisher? Now, what would Larry be able to do in order for it to become more legit? And when I see this, I look at what the publisher asked or told Larry. So Larry has not sought consent of the publisher prior to doing this. Being a friend of Larry, the publisher warns Larry about the legal implications of linking copyright without permission and ask him to make a formal application to obtain permission. So even if, let's suppose, if I have under any contract given away my intellectual property for a consideration of dollar amounts, I can still ask for using it as a part of my portfolio if even if I feel like I want to use it as perhaps as some of the information and not everything that I have given to the publisher, but let's suppose a piece of it, maybe a picture in this case, I can always ask that if the publisher would give me special permission to use it as part of the portfolio to show others what type of work I've done. Maybe it's a masterpiece for which I'm very proud of and I want it to be displayed in my portfolio. I can ask for a special permission from Larry. Okay. Otherwise, if I want to go aggressive, I can go to the court, but that's not the point because here, if I can go to the court, maybe there is some technicality for which I can actually claim that photo to be available to me as well as to the publisher. So I can go to the court. That is possible. I can just talk to the publisher, and if he agrees, or maybe one email or something in the chat that says, okay, go ahead, you can publish it, I can do that. I can sign a linking agreement with the publisher too. So I can do all of the above. It's not what I'm supposed to do. I can, but what I'm capable of doing. I can go to the court. Yes, I can. In any case, in whatever situation you're contesting, you can always go to the court. You can talk to the publisher. You can sign a linking agreement. So for me, all of the above is workable. Then I've got what is the benefit of linking?
number one.
You know, number one is obviously is something that exactly ties up with what the situation is here, but thinking of it in the general sense of how the question can be answered, um, like the benefit that would come for anyone who is doing linking, generally speaking, not just Larry, but let's look at it from the wider lens. Actually,
Oh, so
yes,
all of the above? Is
I
that
would
what
say
you're
so.
looking at?
Yes,
Okay.
I would recommend that anybody who is going to do inline copying or who's going to do link copying would generally be looking at the benefits, which can include one, two, and three. Because you can't argue that the links appear nice on the web pages if there is so many pictures of somebody else, that looks nice on my website. I would do linking, and therefore, even though it is infringing on IPs, but at the same time, it does not change the fact that it's going to look good on my web page. Then we've got links allow secret access to other. Yes, it does, because the website owners don't know you're sneaking into their database and their own content, including images, pictures. However way you're using the linking, it is sneaking into somebody's websites, web pages without permission. Yes, it makes it convenient. I mean, I don't have to buy a picture. I don't have to generate something on my own. I'm just conveniently using somebody else's material to be displayed on my website. And so one, two, and three would mean that in generality of what benefit would anyone get from linking is all of the above. All right. Piracy. Let me make it bigger fonts over here. So you want to read this one? It's talking about privacy. Piracy, sorry. Privacy, piracy. Now, this is a common occurrence, and still it's happening, especially in small businesses, small companies. You get a license for one software, one user, and everybody is using it. All they do is just place that software in a centralized server where everybody else would have equal access to the same software. And if the software has not provisioned for filtering out the user's access, then of course everybody can use it. But then if it is found that buying one license and, in this case, 30 staff members are using the same software, then of course it's a piracy. Piracy means illegal use of something without permission. That's it. It's very simple definition. So here there is a situation of piracy. And if you have finished reading this part, let's look at the possible answers. First one, what is the copyright infringement activity that they have carried out? this is pet question will come every time. You would know how to answer the like the previous one. If the topic is about linking, and then it is a linking situation. If it is piracy, then of course you're going to just make a choice here as number two to be the correct answer. It's a case of piracy, and it's going to highlight this. Accusing of piracy in this scenario refers to stealing computer software, purchasing one software package for multiple users, unauthorized access to another's computer. So, stealing music, and so 3 and 4 is irrelevant.
Two is
In this
closer to.
particular, yeah, this is a logical answer, of course, the easiest one to highlight. Then we got what is the type of copyright infringement the company is liable for? Is it direct, contributory, vicarious? None of the above. This is a direct infringement. Piracy is always a direct infringement. There are no multiple parties involved. The user who signed for it is just one individual, and that one individual had the intent or had the motivation to reduce cost for his department, and therefore is the direct infringer of that contract for the software. So it is a direct infringement. Who is the main copyright infringer in this situation?
Justin.
This guy is the culprit. Is a smart guy. Okay, Justin is responsible. But then tell me who is going to pay the fine or the cost for it, even though Justin has benefited the company by reducing their cost for their department. So the direct beneficiary is the company, not that Justin is pocketing anything. So how would the software company, it's just my my curiosity, or you could say that just to debate this, why would you think that Justin, who's going to be paying for the piracy in this case? The company or Justin?
The company.
What do you
The
say?
pub. Yeah,
Hmm?
I would say that I would just say the company. They would fire Justin
Hmm.
or suspend him maybe and bring him back. You know, like
Yes.
I've seen situations where a company got rid of the guy or gal that did whatever,
Yeah.
as long as it was in the court system and the legal process was in play. But then after all of that was over, they would bring that same person back and just say, "Hey, don't do this anymore." I mean, some employees nowadays are very valuable. So, like, even if they do something wrong, a lot of times
Hmm.
they, yeah. I
Yes.
mean,
Happens.
yeah.
But if the software company is going to sue anyone,
Well, you can sue anybody, right? But it's collecting the money. So, I mean, if I was the software company, I would go after the company because I know they are more likely going to have the money to that if I sue them. But if they sue Justin,
hmm.
I'm just
So I see what you're saying. So,
yeah,
when you take the case, or supposing the software company has to sue anyone, they're going to sue the company, not Justin. Did you know that?
right,
I'll tell you why. Rationale. One thing is that the who had the maximum benefit uh, of copyright infringement. The company is the beneficiary because
right,
their cost has been reduced. Second is that there is a certain level of responsibility which is assumed for a company to have a responsibility for, in case of software usage. especially in that company, there has to be a management that is responsible, but there has to be a check and balance that is applied in acquiring softwares and using that software, let alone uploading it on their server. Third thing is the location. Where was the software used? Was it used by Justin in his private space somewhere? Private space being his home or somewhere outside of that business? If no, then that is the third criteria. So, what will happen, even though Justin is responsible for it, but let's look at question number 5 in the light of what I just explained to you. So, what is the risk of using pirated software according to the above situation? Okay, a lawsuit can be filed against such individuals or company. Here, the so, the company, the software company will sue both Justin and the business itself. But generally, they don't sue whoever is the purchaser. They generally sue the beneficiary of it. Okay. Okay, so let's suppose in this case, when it is using or company, it's just becomes a choice for the software company to sue either the company or individual. But guess what? The company cannot sue for a maximum amount just from an individual. They'll be better off suing the company, and they would have a good chance that the company will pay them for the damages. Second is the risk. The other risk is compelled to pay a significant fine, of course. For 30 licenses versus one, you're talking about 29 less licenses. That could be significant. Potential private and public embarrassment comes naturally, of course. If somebody finds out that that's how they operate, then that could be a cause of embarrassment. All of the above is what my answer would be, quite honestly, on number 5. Plagiarism. Okay, let's read this one. Todd is a senior at the university and only one separate graduation is part of the course social psychology. He was given an assignment to submit at the end. Professor William House. Excuse me. So this is plagiarism or not? First of all, at least from these three paras, we know that it is within. It is a breach of intellectual property by not giving attribute or not giving reference or not citing it. So the answers you can see for the first question, what is the offense that Todd is liable for? Plagiarism. So in every single use cases, the first question you can always get the right answer. That's how they put it. Plagiarism is what is happening. I'm going to highlight this. Then the second one says, what are the unlawful acts he has committed in being liable for plagiarism? What are those? He had used both library resources and online material. He used direct quotations.
Paragraphs without citing references.
He had written the paper in a draft format. He delays the submission. So using library sources and online material is not plagiarism. Draft, writing it in a draft format is not. Delays submission of the paper. So 3, 4, and 1 are logically are not the correct answer for this. So we are left with number 2. He used direct quotations and paras without citing references. Citation or citing references one can do in 2, 3 different formats, but those formats are already uh, acknowledged or considered as standards in wherever the citation in a formal writing is to be included. Citation has to have attributes, which includes not only the link or the source disclosure of the source, name of the author has to be there, and what else, Majdi?
He,
What would you include in citations?
you
There are
put the
different
author.
formats. Hmm?
Can you hear me? Because the parameters of Zoom for me has been changed somehow. I don't know whether you can hear me well. The camera
No,
is
no,
not working.
what should be part of the citation that
Yeah, yeah.
you put in as a reference? What are the
That's
elements of a citation generally?
well, for example, for a book, it has to be the name, the initial, the date, the edition, yeah, the name of the edition, even actually the town or the city where the book has been published. Yeah,
Mhm.
yeah, these are the ones that I can think of. And for websites, you need to add the date as well that the website has been accessed at, for example. Yeah. Generally these, but if it's a quotation, you need to add the page, for example. If it's just
Mhm.
uh, uh, phrases that you are going to paraphrase from the source, you don't need to add the page. But if you are going to put a citation with the quotation, you have to add the page. Yeah,
Correct.
yeah.
So first of all, you have to put the quoted or anything that is copied, which needs a citation to be part of it. It needs to be within quotation so that it can be distinguished or it can be set aside as different from what is the rest of what the rest of the para or rest of the text is talking about. So that is number one. Number two is that citation reference has to be something which must include the name of the author, the institution where it is coming from, the title of it, and the link where it is leading to. And in case of books, as Majdi has mentioned, the page numbers from that book, anything that makes the citation credible is the completeness of the citation or the completeness of the information that makes a citation. So there are different formats of it. People use with formats, meaning not only the elements that are included, but also the way it is written or how it is described. It has to have a consistency or it has to follow a certain rule. If it is one single document you're talking about, then the format of that citation has to be consistent so that it's not going to cause any confusions. Anyway, the answer to number 2 is
Number 2.
number 2. So I'm going to highlight that. What are the best practices in Todd that Todd may have followed correcting his mistake? Can you read this?
Uh, yeah, that's better. Number 2.
Correct. What could have been the strategies that Professor Williams explained to Todd? All of the above.
Right.
Yes.
All of the above.
Of the above. Yes. Good. Defamation. This is interesting one. If you care to read this through, let me this on this side. Okay. I think we can start answering the question, starting from question number 1. What is the offense committed by the commenter identified by the pseudonym Eric? So what has Eric done to Martha that, that made her so upset that she's looking at the legalities to see if she can file a legal lawsuit. Um, Obviously, it is what is it? Slender or libel? It's libel, right? Written
Yeah.
comments.
Yeah.
So what is it? My pet answer for the first question always defamation. Of course, it has to do with
Defamation. Right.
so defamation. Let's move to the second one, which is more meaningful, I guess, from first one. What is the type of defamation that Eric is responsible for? Libel.
What libel?
According to the above scenario, what is the defamatory act committed by Eric? Let's see if we can get a correct answer for this one. Post-offensive, what is the defamatory act? All three, 1, 2, and 3. All of
It
them is
seems, yeah.
it seems that well, that's that's really nasty. Well, Eric has done a good job here, seems like. What is the medium, excuse me, through which defamation has happened in this scenario?
Wow.
Yeah, it's a blog. See, blog has this characteristic typically where it allows for people to put comments, and that, or at least that is the format of how the blogs are presented or presented for online viewing. So definitely, I mean, this is blog. Which of the following are elements required to establish a case of defamation? I guess the last question is more important than any other.
Two.
Yeah, all the above.
So if this is the case, it's not a case of a, well, it could be a public figure technically if she has a lot of followers, I would say.
That's true.
False statement of facts. Who knows if it is false or not? I mean, it is a platform that allows for the comments to be placed there. It is just a freedom of expression and the net neutrality, which gives equal rights for anyone to put the comment there. False statement of facts, I wouldn't know if it is false or not. I mean, you can't tell, I can't tell. We haven't read a blog. Then we've got a publication to one other than the person, of course. There's more viewers. So one
Yeah,
is there.
but the question says, which of the following are elements required
Yes,
to
it's a
establish?
Correct. So
To
it is
establish, right? So it just to just to establish it.
right.
I'm going with number 2.
Mm.
And
No.
then
when you were mentioning
wait a
this,
minute.
all of the above.
Yeah, right. Yeah,
Yeah,
because
you just gave an answer, but you uh picked this
yeah,
number 2.
I'm just trying to participate and make it interesting. But yeah, the more I
No, it
look
is
at it,
good. I like it. I mean, at least somebody is giving their opinion, which makes it more interesting and more interactive. The last one, let's do this one, and then we'll finish up. So, what does this say? Rachel purchased 3 academic books, when the packaging, she realized that.
wow.
This is what happens, especially during Christmas time. As the next step, contact the stores elsewhere. Yeah. So what happened with Rachel is that she took all the actions and probably followed all the processes to obtain a replacement from the vendor, and
Wow.
giving a choice to either refund the money or get a replacement. Since the book have cost her a considerable sum of money, she was not willing to give up easily. She decided to seek help of a lawyer. Lawyer asked her whether she has signed an agreement at the time of purchasing the book. Said that the only thing she was, uh, see, I agree. What is this? Click wrap agreement? It is click wrap. You have to click on something to agree or to accept before you can move to the next page at the bottom of the page. Her lawyer stated that this is enough to pursue legal action against the perpetrator since it covers the key elements of binding contract. So even if most of the companies that have these click wrap agreements, they do have an element of mutual obligations, which gives rise to rights of the consumer, or there is a section which gives rights to the or the beneficiary, or the someone who's buying the product as a customer, and at the same time it also lays down a process of how you're going to make those returns and what is their exchange policies or what is their replacement policies, etc. So anyway, just clicking on the agree agreement means that it has an obligation from the vendor as well as an obligation from the user or the consumer for certain processes they have to follow in case in a situation as in with Rachel to return the product. So lawyer is saying that it's favorable. Actually, it is not a one-sided agreement. It is an agreement from which you can derive benefit to the extent where you are given the certain rights for returning the book. So what is the type of e-commerce that Rachel is dealing with? This scenario is business to consumer, so B2C. This number 2. What is the type of e-contract that Rachel had entered into? So this is a click wrap agreement.
Click wrap. Okay.
What are the key elements of binding contract that the lawyer may have mentioned? Offer, acceptance. So there is a contract, there is an offer, there is an acceptance, and there is a consideration. Otherwise, the contract, you can't just put a set of rules and terms and conditions without a contract, just so you know. So it is not like an e-commerce agreement which is devoid of the rights of the consumer to not and also to just maintain a one-sided agreement that only benefits the owner or the vendor of that website. Okay. What are the key elements of binding contract? Offer, acceptance, consideration. So all of the above.
All of the above, right?
What are the things that Rachel can use as valid evidence to support her case? Everything. Emails she sent, recipient of payment, hotline contact. So if she has records of all of these, all of the above, assuming that this was a process which is described in the contract, then she has done all of it. Or, commonly, common sense says that if you have covered all the three, then it is all of the above. Which of the following laws gives validity to electronic contracts? Computer fraud and abuse, communication, privacy, electronic signatures.
Hmm.
Honestly, I don't even know this one. I don't
Yeah,
know this one. But more than likely, this question, if I remember correctly, this question is taken out. But what it was replaced with, I forgot. However, just using a common sense, what would you think? Validity to electronic contracts, computer fraud and abuse. This
yeah.
Fourth one
sounds
seems.
correct. Anyway, so we are able to finish up all six of them. Next is ethics. What is ethics? Just to give you an idea what ethics is, I know it's slightly over your time with me, but just generally speaking, ethics means the moral values of certain acts that you would do in order for you to obtain the information available on the internet. Ethics means that how you, as someone who grew up in a certain society, the norms of those society give you as values for doing the right thing. Um, it can be privacy that you will have to respect of others. It could be a social values which would differentiate between what is considered not only as private but morally private, what can be considered as abusive, what you should protect for others and for yourself in terms of mm, the ways in which you obtain the information, the way in which you display the information. There is an element of respect which is more on the personal side of how you would respect others and have the value for the same respect that you expect to get for yourself. And in order to do that, there are certain social norms which, even though are regulated by the law itself, which is a guideline uh, to maintain or to keep a restraint of for actions uh, that would be in sync with the norms of the society. So you would follow a certain ethics of value that you would consider to be part of the society or acceptable to the society for the better delivery of your work. And I'm here talking about research work primarily. So, issues that you can understand better when we are dealing with privacy, confidentiality, and anonymity. Okay. Uh, how about Googling clients? Like if you have to hire somebody, would you look at somebody's private information that somehow got captured on the social media accounts? Would that have an impact? And by the way, this could be real or it could be generated for some personal reasons. I know a lot of people in LinkedIn, they don't put the correct information or they put some more information which may partially be correct. It's not as accurate. So, how much of a reliance you would have for collecting information that by the way, can also be time based. Like somebody might have done something 5 years ago and now is reformed or changed, or the habits are changed, or their interaction is changed. Would that be something that you will bring into account for, let's say, hiring someone? What is the role of AI? This is the in thing these days. It's our AI means artificial intelligence. So, what would you think that without your consent, if the CCTV is capturing you or your or there is there is no human element involved in mechanically drive decisions, which means that certain sentiments or certain privileges, certain type of information is not brought into account, or the circumstances surrounding certain type of events are not correctly understood by the artificial intelligence. What would you think the accuracy or the decision level would be if you're going to rely totally on mechanically derived outcome through artificial intelligence? Would ethics have a role in there, and to what level? Ethics is mostly interpersonal, and it is relative, and it has got certain elements which cannot be totally captured mechanically. So that is a debatable line between ethics of content sensitivity. What is sensitive in Eastern, let's say in Islamic countries versus more Western countries with the Western values? What could be their sensitivity levels as far as sexuality or gender differentiation and things like that? You have to be sensitive about it. The kind of things that you will be putting in or be sensitive about, or at least feel the sensitivities of a society, will depend on where you grew up or where you are operating. If it is North America, it is obviously different from the third world, and so on and so forth. So I'm just giving you an overview. I don't want to stretch it too much, but these are some of the questions that are part of your slides. If you look at the PowerPoint PDFs, these are pointers. And on top of this, I'm going to send you a link which is going to discuss the ethical issues of the internet for, let's say, about 10, 15 to 20 minutes of video. I'll send you the link for it, and it will be actually placed in your recordings. So I would like to conclude everything with the exception I just described, um, to say that your CIRS course is complete from my end, and I feel comfortable that you would not have any problems in passing the exam. I have full confidence. I saw, Anthony, you were attempting some questions and you did a good job. I believe you passed the first module. So
Oh, wow.
it seems that everybody is motivated, and I
Yeah.
encourage you to get this wrapped up as soon as possible because everything is fresh in your mind. So let's say then when the new year starts 2024, hopefully some of you would have already qualified. I wish you good luck for 2024, and I wish you happy holidays. And I want you to keep in mind that, and of course, Merry Christmas, not to forget that. Uh, Keep in mind that I can be in touch through the email. And if there is a question regarding CIRS exams, then I'll be more than happy to revert back to you at my earliest convenience, which would be very, very soon after I get that email. And that is because, you know, I want to assist you with your CRS exam. So, with all this and with your attending all my classes, special thanks to four of you, including Joanne, who I didn't see today. I wish you well. So, thank you and all the
Thank
best.
you.
By the way, there will be a survey link that will be sent to you. So keep an eye on that. I hope it doesn't land in your spam folders. That is also important. Thanks. So
Well,
say
thank you.
goodbye to
Thank
All
you.
everyone.
right.
All the
Thank you.
best.
Thank you,
Take
and
care
all
now.
the
Bye bye.
best.
We
Thank you
made
very
it.
much.
Yay.
Bye.
Did it.
Bye.
Very
Take
good
care.
job. Very good job. Very proud of you all. Thank you so much.
All right. Thank you.
Thanks.
Bye.